Welcome to Law of Contract. So we are continuing with discussion of vitiating factors. So far, we have covered mistake as a vitiating factor. And for that matter, we propose to continue with another vitiating factor, misrepresentation. But just before we do that, you notice that when we're discussing mistake as a vitiating factor, we did make the point that we are not talking about mistake of law, we're talking about mistake of fact. And again, we're also talking about an operative mistake. That is to say that a mistake which actually existed at the time that a person was supposed to have given his or her consent to a particular transaction. For that matter, had it not been that mistake that he or she would not have given that consent, and for that, and to use the words of Lord Atkin and Bell and Liver brothers, mistake in that respect could be said to be either negativing consent or nullifying consent. And again, we also noted that mistake will produce or may produce different consequences, as whether you are dealing with a common law or you are dealing with the equity as it were. And of course, at common law, all the time where mistake is established, the contract will be considered null, void ab initio. That is to say that it's a nullity or it never existed, as it were. We have seen that. But then in limited instances where equity applies, then the mistake, as we noted, will not necessarily render the contract void, but voidable, in which case a party can take steps to have the contract set aside or the contract avoided so that he or she is liberated from the effect or the consequences of such a contract, which is vitiated by mistake. So let us keep that in mind. And I think that the other significant thing we touch on is the fact that we have three types of mistake. We have like the common mistake in which both parties have made the same mistake, especially mistake, let's say the res extincta, where they thought that the subject matter of the contract actually existed at the time that they were making the contract, when as a matter of fact, it did not exist. So typically, I remember the case of Kutura in hairstyle, and that has given rise to a statutory provision in the contract, in the Sale of Goods Act, Act 137, that where you are making a contract as to specific goods, there is an implied obligation, implied condition on your part that that item will be in existence. And that provision is as a result of the case law we call the Kutura and hairstyle. And again, we also talk about mutual mistake where both parties are mistaken, but they've made, as it were, if you like, a different type of mistake. In other words, both parties understood the contract or what the subject matter of the contract or the terms of the contract in different senses. The offeror made the offer understanding it in a certain sense, and then the offeree also purported to accept the offer in a different sense. And because they have a fundamental misunderstanding about what was being offered and what was being accepted and all that, the case law will say that the parties were not consensus addendum, or they were at cross purposes. And a very typical reflection, as you saw, the case of a Raffles and Wichelhurst. So therefore, where there's an alleged mutual mistake, as we noted, the court will endeavor to apply the objective test of agreement. Now, when the objective test of agreement is applied, that is to say that the court will try and find out, assuming there was present when the parties were making the contract, what we call a disinterested reasonable person or officials bystander. How will that officials bystander or that disinterested reasonable person who have understood the parties to have really meant? If the objective test is applied and the court is able to arrive at some kind of agreement, then despite the fact that in the subjective minds or the subjective intentions of the parties, they thought that there was no, if you like, consensus that did them, the court will still say that there's an agreement because the test of agreement is subjective, it's not subjective, as it were. And finally, we also talk about unilateral contract. A unilateral contract, as the term itself suggests, only one party is mistaken regarding the contract, and usually it is in relation to the identity of the other contracting party. So where that is the case, quite often the other party who is not mistaken is just being fraudulent, trying to play fraud on the other party, in the sense that he knows that the party he is actually contracting with is not the one that he really wants to contract with, but he just wants to take advantage of the ignorance of that party and then fix him with liability, take his money or value, and will subsequently disappear into thin air. So if you read the case law, such a person is usually known as a rogue or a fraudster. One case to read, I've read a lot of them, a lot of old cases, Keynes, Norton, and then Lewis and Ivory, Phillips and Brooks, Candy and Lindsay, Ingram and Little. But a more recent authority I would like everybody to read, in addition to all the cases we're giving, the case of the Shogun Finance, right, against Hussein. Shogun Finance against Hussein is, and then the Great Peace. Okay, so these are some of the points which we sought to cover when we discuss mistake as a vitiating factor. So having said that, we'd like to welcome you to another segment of discussion of vitiating factors. And as I said, we are looking at the misrepresentation, and hopefully we wind it up with the duress and undue influence, so that we're able to say goodbye to vitiating factors, and our next class will be able to discuss illegality in public policy, and then we'll be left with one last topic, that is the discharge of contract, and we are ready for examination. Okay, good. So we will try and first do a brief introduction, understand misrepresentation, and then look at the various types of misrepresentation and the remedies which the law provides for misrepresentation. First of all, as we have already made the point, misrepresentation is one of the elements or factors which may undermine, that is, vitiate or invalidate the agreement between the parties. Of course, it's not the only thing. We know others, as we have been talking about them. We'll be looking at, if we just talk about mistake, we'll be looking at the duress and undue influence. Of course, illegality is put there, but illegality arguably is not a vitiating factor for some scholars, but We will look at that when we get there. Now, where a contract has been made as a result of misrepresentation, then such a contract is voidable at the request of the party who is a victim of misrepresentation. So mind you, we are not saying the contract is void. We said it's voidable. Voidable means that in the eyes of the law, the contract is valid for the time being, but at the instance of one of the parties who is affected, the contract could be set aside so that it will no longer be treated as a valid contract. So voidable contract, if you like, has what they call like a temporal validity. For the time being, is valid, but its validity does not last, since it can be taken away at the instance of a party who is affected by it. So let's keep that in mind. And that is why we also add that where you've actually established misrepresentation, it does not render the contract void. Again, it does not render the contract void. The reason being that it just denies that party the right to continue the contract if that is in that party's interest. So if you think that because you've discovered misrepresentation, you're uncomfortable with the contract and all that, and you like to be released from the contract, then the law allows you to get a release because of the misrepresentation that you have discovered. And that is why we're saying that it renders the contract voidable, but not void. So let us keep that in mind. Good. Having noted that, question is, what is misrepresentation? Misrepresentation occurs when a false statement or representation of facts is made by one party to the other party before or at the time of contract, which has the effect of inducing the other party to enter into a contract. So looking at that definition, key things which stand out are the fact that there's a false statement, right? A false statement or representation of fact is the same thing. If you say you've made a representation, that is a statement, right? But we are not talking about just that, we're talking about the falsity of it. So that statement or that representation of fact is false, is not true. Good. So if you like, the person who make that representation can be called the representer, or the false representation becomes, if you like, the misrepresenter, as it were. Now, not only that, again, it is supposed to have been made before or at the time the contract is made. And that is to say that if you are complaining of misrepresentation and you are unable to link the misrepresentation to the formation of the contract, so that you are not able to show that you became a victim of the misrepresentation before or at the time the contract was made, then your misrepresentation will not be entertained. Because if a misrepresentation is after the contract, there is no misrepresentation. Because if you look at the other element, it said that it has a effect of inducing the other party. The other party, that is the party to whom the false statement of fact was made. That is the representee, if you like. Now, the representee is supposed to have been induced. Induced means that it's supposed to have been influenced to enter into the contract. And what that means is that had it not been for that misrepresentation, he or she would not have entered into the contract. Yeah, so where these things are there, then we could say that misrepresentation exists. Good. Of course, misrepresentation, the statement giving rise to misrepresentation can be in any form. It can be in writing. For example, as in a company's prospectus. So when you say a company's prospectus, that is, if a company wants to invite other people to come and subscribe for its shares or other securities, the company will package information about itself. Just as we saw when MTN wanted to make its initial IPO in Ghana, it wanted to open up to a lot of people to acquire shares and get its shares listed on the stock exchange and all that, where they package a lot of information about itself and various people could actually read it in order to make up their mind whether they want to invest in MTN or not. So that is prospectus. Again, misrepresentation can also be verbal. That's just by word of mouth. Or sometimes it will be implied from conduct. The person may not expressly say something, but a person may not expressly say something, but he or she may put up a conduct, and the conduct may be direct or indirect, if you like, positive, or if you like, omission. Of course, when it comes to omission, it's limited, but we talk about that, especially as whether silence can give rise to misrepresentation. So we're talking about that. Good. Yeah, so we've discussed the essential elements of misrepresentation. And you said that if you are trying to understand misrepresentation, we must be thinking of it in terms of a statement of material fact. That is, did the other party make an important statement? If you say important statement, that is a statement relating to important aspect of what you are about to enter into contract, what we are contracting about. And then, of course, that is made by one party to the contract to the other. And what this means is that you cannot make a misrepresentation to yourself, okay? You cannot be a victim of your own misrepresentation. That is inconceivable. So let us keep that in mind. And again, we've also said that the statement which will give rise to the misrepresentation should be a statement which was made during the negotiation leading up to the formation of the contract. And not that alone is not enough. The statement should have been made with the intention to induce, right? With the intention to induce the misrepresentee, that is the other party. And for that matter, if upon closer examination, the statement could not be said to have been intended to operate and actually did operate as an inducement to the other party to enter into the contract, that statement cannot give rise to misrepresentation. It cannot give rise to misrepresentation. So that is very important. But it is not every statement which induce a person to enter into the contract that will be considered misrepresentation. The statement must have been a false statement. If it's not false, then it doesn't give rise to misrepresentation, because truth is truth. Okay, so we have said that to constitute misrepresentation, the statement alleged to misrepresentation must be a statement of material fact. That is, it must be a statement of fact and not a statement of opinion. So the general rule is that a statement of opinion does not give rise to misrepresentation. That is the general rule. And for that matter, if we look at the case of Bisset and Wilkinson, a farm had never been used for raising a sheep. When the owner of the farm was selling it, he made the statement that it could support the raising of 2,000 sheep. Now, the purchaser later on discovered that that was not true about that farm. And for that matter, he sought to sue for rescission of the contract. And the court held that having regard to the evidence which came before the court, the statement that the farm could support 2,000 sheep was merely a statement of opinion, which the seller of the farm honestly made, despite the fact that such a statement was mistaken in the sense that it was not true. And why is it not true? Well, the farm had never been used previously to do sheep farming and all that. So the question is, how could you be certain that such a farm had the capacity to raise 2,000 sheep? So that was the position that the court took. Yeah, so that was just an opinion. Yeah, so Bicet and Wilkinson, an authority for the proposition that a statement of opinion as a general rule does not give rise to misrepresentation, even if it turns out to be false. But as I said, that is just an exception. That is just a general rule. And to a lot of general principles in law, we have exception. So we have an exception to the rule that a statement of opinion does not give rise to misrepresentation. That is to say that in some instances, it could give rise to misrepresentation. And typically, where the statement of opinion was made not just by an ordinary person, by someone who professes or who holds himself out as having some expertise, then such a statement can give rise to misrepresentation, as happened in the case of Esso Petroleum against Marden. In Esso Petroleum Company against Marden, Marden took a tenancy of a filling station owned by Esso, and having been given a forecast, that is estimate, by an experienced Esso sales representative of the quantity of the petrol station, or petrol the station could be expected to sell annually, what they call the throughput. The quantity was never reached during the 4 years. Marden remained as a tenant, and the business ran at a loss. So Marden sued for misrepresentation. And the court held that the company had made a misrepresentation since the sales representative knowledge of such matters made the forecast a statement of fact rather than opinion. And the sales representative was acting in the capacity of an agent of the company. And for that matter, the claim for damages for misrepresentation in the court view was successful. So here, unlike Bicet and Wilkinson, where the court said that the seller of the farm was in the same position as the purchaser of the farm because the farm had never been used for sheep farming. And for that matter, the vendor could only be conjuring up, if you like, stories, since he had no basis. But in Esso Petroleum, the court is telling us that the sales representative who made statement regarding the capacity, that is the sales potential, right, of that particular filling station, which was being stored, by reason of the fact that the company, that is the Esso Petroleum, had been running its business at that station for quite some time. They knew how much the station could actually generate in terms of revenue over any period of time. And for that matter, if they are making a statement regarding potential sales which could be made at that station, they must make a true statement. Otherwise, if they say anything, they will only be deceiving the recipient of the information that they representee. And that was why the court was prepared to take the position that despite the fact that the statement of the capacity of the station ordinarily would have been a statement of opinion, but this statement of opinion was not just an ordinary opinion by a lay person, by someone with some reasonable expertise. And for that matter, that should suffice as giving rise to misrepresentation should same turn out to be untrue or false. So let us keep that in mind. Yeah, so as we have indicated, the clear point is that it is not possible to avoid liability for a statement which is expressed or subsequently claimed to be an opinion when the knowledge and experience of the representative in the matter is far greater than that of the representee. So this is like the point of distinction between SF Petroleum against Martin on one hand, and then the earlier case of Bisset and Wilkinson on the other hand. Another point to note is that in talking about misrepresentation, the alleged statement, that is the statement alleged with misrepresentation, which must be a statement of material fact, also means that it should not be a statement of intention. In other words, as a general rule, a statement of intention will not amount to misrepresentation. And the reason is that a representation is a statement about existing facts or past events, not about future tense. So a statement which will give rise to misrepresentation should not be a statement which lawyers will say in futuro, that is something which is futuristic. No, it should be something which is here and now, or which was. So let's keep that in mind. That is the general rule. But it is possible in a limited instance for a statement of intention, that is a statement pertaining to the future, to be treated as misrepresentation. So if you make a statement regarding what you intend to do in the future, right? And if it can be demonstrated subsequently that when you made the statement regarding what you intend to do in the future, you never intended really to do that, then despite the fact that ordinarily speaking, the statement that you made was a statement about what you intended to do in the future, because there is evidence that you never intended to do that, that statement could give rise to misrepresentation. And that is exactly what happened in the case of Edgerton against Fitzmaurice. The directors of a company invited members of the public to lend money to the company, that is to subscribe for its securities. And the director stated that in the prospectus, I've told you about the prospectus already, that the money will be used to improve the company's buildings and extend the business of the company. However, subsequently, it was uncovered that the rare intention of the directors in trying to get money from the investing public was rather to pay off the company's existing debts. And because of that, the court held that the director's statement was fraudulent misrepresentation. Now let's look at it. The statement in the prospectus, or the statement seeking to entice members of the public that wanted to invest, right? That wanted to invest in the company. Among other things, said that yes, please, whatever money we are going to generate, we are going to use it to expand our businesses and all that. Now, this certainly pertains to the future. However, in the course of time, the evidence became clear that the directors never had such intention, and rather, the company was owing so much debt. So they were just trying to raise money to pay off the existing debt of the company. So not necessarily for expansion. And that was why the court was prepared to conclude that then the statement that they were going to use the money for expansion was a statement of intention and could still give rise to misrepresentation because there was no basis for having such intention. And that is why, if you read the cases, you come across one of the judges who will make the point that the state of a person's digestion in the stomach is very much a fact. In other words, if you are talking about what you are going to do, and there is evidence to show that you actually do not intend to do that and so on, then that could give rise to misrepresentation. So let us keep that in mind. Again, that the statement alleged to be misrepresentation by the statement of material fact also means that silence as a general rule will not amount to misrepresentation. Silence as a general rule will not amount to misrepresentation. And what do you mean by silence? That is to say that where you are making a contract with the person and you refuse to make disclosure, you don't disclose certain information or certain facts. And because of the non-disclosure, maybe the other party assumed that the opposite or the contrary is true. And on basis of that, proceeds to enter into the contract. Can that give rise to misrepresentation? Well, the general position of common law is that that cannot give rise to misrepresentation because you've not made any statement, so to speak. And again, the common law does not impose obligation on anyone to be a volunteer. Being a volunteer means that to be on the frolic of your own and be giving information when none has been solicited from you. You have no such obligation. Nevertheless, there are instances or circumstances in which silence will constitute misrepresentation. One, when a statement made in the course of negotiation subsequently becomes false and is not corrected, that can give rise to misrepresentation. Two, when silence distorts a literally true statement, that can also give rise to misrepresentation. So let's take, for example, the case of R&, Castland. A company, when inviting the public to subscribe for its shares, stated that it had paid regular dividends throughout the years of the depression. So this clearly implied that the company had made a profit during those years. Now, this was not the case since dividend had been paid out of the accumulated profits. of the pre-depression years. And the court was of the view that the company's silence as to the source of the dividends, that is where it got profits to declare dividends, was misrepresentation because it distorted the true statement that dividends had been paid. Dividends had been paid, but the dividends were paid from some accumulated money before the depression era. And that is why we've made the point that when silence distorts a literally true statement, that can give rise to misrepresentation. And again, three, another instance where silence can give rise to misrepresentation is where the contract is of utmost good faith. That is, you are dealing with what you call the uberrima fidei contract. Uberrima fidei. That is, the contract requires utmost good faith, honesty. And what are those types of contract? Like, for example, if we are talking about a contract between, let's say, you are going to take insurance policy. You are going to take insurance policy. That is an example of a contract which requires like the utmost good faith. And then you are required to make a disclosure so that if there is some information about you, which you have made the insurance company, for example, decide not to sell the insurance policy to you, or to calibrate your premium up to a certain amount or certain level, and you remain silent so that they give you a wrong quotation, that could be treated as misrepresentation, because such type of contract requires a good faith, honesty. You have to be open and sincere. Again, there will be no misrepresentation where the statement is made by a third party, unless that third party is agent of the party against whom the misrepresentation is alleged. And of course, this one is obvious from our discussion of even offer and acceptance. It is a party to the contract whose statement, when turns out to be false, can be treated as constituting misrepresentation. And for that matter, where it's made by a third party who does not have authority of a party to that potential contract, then that cannot give rise to misrepresentation. So look at the case of a payment against Lanjani. Again, in the statement, which was alleged misrepresentation, must have been made before or at the time of the contract. We've talked about that already, but we need to zoom a little bit on it, or get a bit of like a closer consideration. That the statement of fact, which turns out to be false later on, for you to count as misrepresentation, must have been made before or at the time of the contract. So that is very important. The reason is that way we can show that it operated on the mind of the representee, that it exercised its mind. It had an effect on his judgment before he or she entered into the contract. So let us keep that in mind. Now, if the statement was made after the agreement was reached, then despite the fact that it is a false statement, it cannot be actionable as misrepresentation because it had no effect on the formation of the contract. So what we should keep in mind is that by misrepresentation, we are talking about the context of formation of the contract. We are not talking about after the contract is made. We are talking about the either pre-contractual or the contractual formation of the contract. And that is why the statement of fact, which turns out to be false, should have been made at the time that the contract was made. So let us keep that in mind. And a good illustration of the point that the statement should have been made at the time the contract was made, or before the contract was made, is the case of Roscola and Thomas. The case of Roscola and Thomas. Now, if you look at Roscola and Thomas, there was a contract for sale and purchase of horse. Now, after the purchaser had made the payment, the seller, whether out of unnecessary enthusiasm or excitement, made the statement that you've made a good purchase. The horse, this horse is sound and free from vice. In other words, the seller of the horse, having concluded the sale, was giving, if you like, a more positive statement about the horse, or the appellation to the horse, so to speak. And later on, it was demonstrated that the horse was really unruly and also had a vicious character. That is to say that the rare behavior of the horse was contrary to what the seller had said about it. So the purchaser felt that he had been deceived and wanted to get the transaction rescinded. And when the matter came to court, the court held that the claim of the purchaser will not succeed because the statement or the promise regarding the quality of the horse was made after the agreement and not at the time of making the agreement or before the agreement was made. For that matter, the crucial element that the statement which will give rise to misrepresentation must have been made before or at the time of the contract had not been satisfied. So let us keep that in mind. Another point which we have made already and we want to develop further is that the statement alleged to be a misrepresentation must be an inducement to enter into the contract. So we are talking about the inducement element. And that is to say that for you to succeed in bringing action as actionable misrepresentation, you must be able to show that the statement of fact, which has turned out to be false, okay, had material significance on your judgment. In other words, it influenced you in a significant way in entering into the contract. That is to say that if it had not probably been for the impact or the influence of that statement, which has turned out to be false, you have probably not have entered into the contract. So you relied on it. So inducement actually comes to the fact that yes, they do rely on it. Of course, relying on it does not also mean that you rely only on that only. That is to say that there's no exclusivity. You could have been influenced by some other thing, but insofar as there's evidence that you rely on this statement of facts, which are turned out to be false, you have satisfied the requirement of what? Inducement. So Let us keep that in mind. There are a lot of cases in the literature. For example, Jeff Fasteners Limited against Mass Bloom. The claimant engaged in a takeover of another company. And this was done for the purpose of obtaining the services of two of the directors of the other company, rather than for any commercial advantage in the takeover. Those of you who follow the news, you know the takeover or the sale relating to the company called like the Twitter, if you follow the international news on business. Now, in investigating the company prior to the takeover, the claimant rely on the company's accounts, which in fact have been negligently prepared. There could be no claim of misrepresentation since the purpose of taking over the company was to secure the services of the directors. And for that matter, the court was of the view that the accounts could not have acted as inducement. They are not material to the real purpose of the contract. Yeah, so we are talking about the false statement producing material, if you like, impact or being important in your decision to enter into that contract. So here, you notice that the main thing which they were seeking to achieve was to get the services of some directors, not necessarily because they wanted to maybe make more money. And so far as trying to get the service of two directors as the reason for making the takeover, then the court came to the conclusion that if there had even been some errors in the company's account, right, by those who put the accounts together, that cannot be considered as an actionable misrepresentation because it does not satisfy the requirement of being materially significant. In other words, in terms of what really exercised the mind of the misrepresentee to enter into the contract. So let's keep that in mind. Now, the caveat is that it will not matter that the representation will not generally be considered as an inducement, provided that it did in fact induce the claimant to enter into the contract. So as we have said, it may well be that there were other, other things which, for example, also influence the misrepresentee. So long as it was one of those things, the false statements of one of those things which exercise the representee's mind, the requirement of inducement will have been achieved. So look at the case of Moose Prime Properties Limited against Ad Hills Properties Limited. 3 properties were sold by auction. In advance of the auction, there was a misrepresentation concerning the existence of an outstanding rent review, which could result in increased rents and therefore increased revenue, making it more attractive proposition. The defendants unsuccessfully challenged the claimant's claim for rescission, arguing that the statement could realistically induce nobody to enter the contract. But when the case eventually made its way to the English Court of Appeal, it rejected that defense and rather held that it was not important whether or not a reasonable bidder who have been induced by the representation. The question was merely whether or not the claimant in the case have been induced by the representation to enter the contract. So therefore, what Mr. Prime Property Limited is saying is that even if the statement of fact, which has turned out to be false, may be considered by you to be something which should not, for example, induce any person, any reasonable person or whatever, that will not really make the difference. So you notice that the court is trying to say that when we are trying to establish the element of inducement, it's not so much about the objective test. It's not a question of whether a reasonable person will have been induced by this statement. But what is important is that whether in the circumstances of a particular case we have on hand, is there evidence that the person was in fact induced? If there's evidence that the representee was in fact induced, then it does not matter that maybe some other reasonable people wouldn't have been induced by such a representation. So that is the point the court is making. Now, it is also worth noting that the misrepresentation must induce the person to enter into the contract. And we have, of course, made this point over and over again. And the rider is that where you are, let's say, that unaware of the representation, okay, a representation is made, but you're not aware of it. If you're not aware of something, you cannot complain that it influenced your judgment. Or where a statement of fact, a representation is made, but you choose to do your own independent investigation so that you don't rely on the statement of fact, which subsequently becomes false and all that, you cannot complain about misrepresentation. So the caveat being sounded here is that if a statement of fact is made and you choose to do your own, maybe to use your own skill to ascertain the veracity of it before you proceed, then if later on that statement turns out to be false, you cannot complain of misrepresentation. So that's what they're talking about. Or if you don't believe in that statement of fact, then what it means is that you have not been influenced by it. And for that matter, even if there's evidence later on that it is false, you cannot complain of misrepresentation. As happened in the case of Atwood against Small, where in the course of negotiation for the sale of a mine, the vendor or the seller made exaggerated statements regarding capacity of the mine. And the buyers did not stop at that. They did not just rely on the exaggerated statement by the vendor. So the buyers appointed their own experts to investigate the mine. And the agents or the experts they appointed reported back to the buyers that the statements made by the vendor regarding capacity of the mine were true. So the independent appointed experts of the buyers, if you like, confirmed the statement by the vendors. And consequently, the buyers proceeded to purchase the mine. Unfortunately, they discovered later that the statements were inaccurate or untrue. So they sought to have the contract set aside. And the matter made its way all to the House of Laws. And the court held that an action by the buyer to rescind the contract must fail because the buyer had relied on his agent's report rather than the seller's statement. There was therefore no misrepresentation. So this reinforces the point we've made that where a statement is made and you choose to verify the statement, and having made your own verification, you go ahead, make the contract, and the statement turns out to be untrue later on, you cannot complain of misrepresentation. So let us take note of that. It's very important. Yeah, I think from our discussion of the terms of contract, we came across the case of Catchman and Hill. So we will not belabor that point. So you can look at it. Yeah, so just to reiterate the points that we have made, just being repetitive again, that in order to succeed in bringing an action for misrepresentation, the most important thing is that the statement made must have been false. And it does not matter that it was innocent or deliberate or whatever. The most important thing is that the statement was false. So this brings us to types of misrepresentation. So we have what we call innocent misrepresentation, fraudulent misrepresentation, and negligent misrepresentation. I must say that not until I think the 1960s, we had only two main types of misrepresentation. That is innocent misrepresentation and fraudulent misrepresentation. So let us keep that in mind. And of course, when the case of Hildebrand against Heller and Partners was decided, and from there, we've come to have another category of misrepresentation we call the negligent misrepresentation. Good. So whether innocent misrepresentation, fraudulent or negligent misrepresentation, it will not render the contract void, as we have noted already, but just voidable. Misrepresentation does not render the contract necessarily void, but voidable as it were. What is innocent misrepresentation? Misrepresentation is innocent where a false statement is made by one person who had reasonable grounds to believe that it was true, not only when it was made, but also when the contract was entered into. So the representor made the statement believing it to be true and felt that it was true when he made it. But it just happens that at all material times, when the statement was made, the statement was untrue, right? The statement was true. The statement was false. So just like, let's say that there's someone who has not learned his geography well, for example, let's say in all sincerity, the statements that the sun rises from the west and sets at the east. And he makes this statement with all the conviction and all the honesty. That is to say that he does not know that the sun rather rises from the east and sets at the west. So what he's saying it innocently. But the fact of the matter is that it is not true. It's never been true that the sun rises from the west and if you like set at the east. I mean, this is just a very simple example. So where you are a victim of innocent misrepresentation, you can have the contract rescinded in equity, as happened in the case of Redgrave against Head. It's about like the sale of a solicitor's practice. So you go and read that regarding the earnings of the practice and all that. When he made a certain statement, because the solicitor had been unwell for quite some time, he wasn't very sure of how much was coming into the practice. So the statement that he made regarding what the practice would generate was untrue. So that was innocent misrepresentation. Then we also have fraudulent misrepresentation. And fraudulent misrepresentation every student of law of contract in the common law world, right, knows this point I'm going to make. And it should not be different for our students who are also doing this course. That is the definition of fraud, and for that matter, fraudulent misrepresentation in the locus classicus, the celebrated case of Dairy and Pig, 1889. It's a case that everyone should know. Yes, yeah, so in Dairy and Pig, fraudulent misrepresentation was defined by Lord Herschel as a false statement made knowingly or without belief in its truth, or recklessly, careless, whether it be true or false. So therefore, if you want to find out whether someone has been fraudulent, right, whether someone has made a fraudulent misrepresentation, we have to be guided by the test which was propounded by Lord Herschel in Dairy and Pig, which you've just quoted. So we have to find out that the false statement, that is the false representation, which the person made, can we say that he made it knowingly? In other words, when he was making it, he was very much aware that the statement that he was making was false. Do we have evidence to that effect? If the person was very much aware that the statement he was making was false, then we have satisfied the requirement of fraud. Or two, the person made the false statement without belief in its truth. If we can have evidence to show that at the time that this person made this false statement, there was no scintilla of belief regarding its truthfulness or veracity. The person made the statement never believing it to be true. If we have evidence to support that when he made that false statement, he never believed what he was saying to be true, then that is also fraud. Or three, he made that false statement recklessly or carelessly, as whether it is true or false. Recklessly or carelessly as whether it is true or false means that he made the false statement without bothering to find out. He never bothered to find out. Especially so when he or she had the means to have been able to ascertain whether the statement he was making was true or false. Now, these three tests are not conjunctive, they are disjunctive. If I say they are not conjunctive, what I mean is that in order to sustain a claim for fraudulent misrepresentation, you don't need to satisfy all the three. if you can make out one, fraud is established. If you can prove that the person made the statement knowing it to be false, you have made out fraud. Of course, the argument will be that how the three tests are, they are naturally related in the sense that if you make out one, you can logically infer the other two even from it. Where if the person made the statement knowing it to be true, knowing it to be false, then certainly what it means is that he didn't believe the statement to be true, isn't it? Of course, they are not necessarily the same, because you notice that there are levels where a person makes a statement which he knows to be false. It is that one very straightforward. Then we have the next level where he makes the false statement and there's evidence that he never believed in the truth of what he said. So that is also there. And then the third one, that one is taking us gradually into what we will later on be discussing as a negligent misrepresentation, where he makes the statement in a reckless or careless manner. That is to say that he has the opportunity to ensure whether what he's saying is true or false, but he doesn't make use of the opportunity and makes the false statement. So that if he had actually availed himself of the opportunity which existed, he could have become aware of the falsity of that representation. So that's what we are talking about. So Derry and Peake is a very important authority you should keep in mind. So what exactly happened in Derry and Peake? Well, there was a company which was authorized to make tramways, right? If you go to UK or some other countries, you see what you call like the trams. The trams is not exactly like a train, but it's a particular type of train. Yeah. So under the law, it provided that carriages might be moved by animal power, maybe horses and so on. But if the Board of Trade gave the approval, then in addition to animal power, you can also move your carriages by steam or any other mechanical power for period approved by a government department called the Board of Trade. Now, this particular company, Plymouth, Devonport and District Tramways Company, they wanted to invite the public to put money in the company. So they issued prospectus, right? We've explained what prospectus already. The company issued a prospectus, and in the prospectus, they stated that, quote, one great feature of this undertaking, to which considerable importance should be attached, is that by special act of parliament obtained, the company has a right to use the steam or mechanical motive power instead of horses. So in the prospectus, the company, in trying to entice the public to invest money in the company, made the public aware that the company had already obtained permission of the government department so that it can use steam or mechanical power to drive its carriages and not just horsepower. And that statement is significant. So what it means is that the company will be able to make more revenue, because if you are using steam or mechanical power, you can move more passengers and cargo around than if you are just using animal power. So that was the implication. Now, the plaintiff in Derry and Peake bought shares on the faith of this statement that The company had been given the power to use mechanical or steam to run its carriages. However, the company was later on refused the consent by the government department to use the steam power. And the company came under so much distress that it folded up, it winded up. And the plaintiff got angry and then sued. But during the trial, the evidence were quite clear that at the time the company was actually issuing the prospectus or making the statement in the prospectus that it had be given the power to run its carriages by steam or mechanical power, it honestly believed that consent would be given by the government department as a matter of course. And for that matter, the court held that the plaintiff action in deceit, action in deceit is the same as where you sue someone for fraud. The action in deceit or the action for fraud must fail, as the statement contained in the prospectus was not a fraudulent misrepresentation, as the company entertained an honest belief that it was true. So what we notice is that in Derry and Peak, the House of Lords, through Lord Herschel, propounded a very useful test for making a determination whether fraud had been committed or not. Nevertheless, the test of fraud was not satisfied according to the facts of that case. And for that matter, the court held that no fraud had been committed. So let us keep that in mind. Despite the fact that Derry and Peak is a locus classicus for fraud, in the Derry and Peak itself, fraud was not made out because the court had evidence that when the company made the statement that it will be given the consent by the government department to use steam or mechanical power to run its carriages, it did so in all honesty. So let's keep that in mind. Yeah, so where you have made out fraudulent misrepresentation, you as an injured party or the victim, you can rescind the contract, right? You can rescind the contract. That is to say that you have the contract set aside. You have the contract set aside and you are no longer bound by the effects of the contract. As happened in the case of Smith New Core Securities Limited against Scrimgeour Rickes. Because of time, we will not be discussing every single case. Otherwise, you'll not be able to finish what you want to finish. But you go and read that. Now let's talk about negligent misrepresentation. As I told you, that negligent misrepresentation is a bit later in time, in the sense that for a long time, that was not actually recognized as a category of misrepresentation, but later on that was recognized. So a negligent misrepresentation is a false statement made honestly, but without reasonable grounds for belief in its truth, if you like. So that's why, so where you've made a false statement, but you don't have reasonable grounds for its belief in its truth, that is but that is too simple, right? Now, the very useful understanding of negligent misrepresentation is the case of Hildebrand against Heller and Partners. And I would like to take you into that case a little bit before we move on. Okay. That's a minute. JK, do you see the new, can you confirm what you see on your screen now? JK? Okay, anybody, can you confirm what you see on your screen? You can raise up your hand so that I will release you. Okay. Kojo, what do you say?
Yes, Doc, I see the slide on negligent misrepresentation.
Oh, really?
Yes.
Well,
it has a headly and
oh no, I
has
changed
gone off.
that. Okay, let me find out because I'm changing the screen. I want to see if you're seeing that one. Let me see 1 minute. What do you see now? What do you see, Kojo? Okay, Kojo is gone, so let's say Gordon. Gordon, what do you see?
Sir, please, I will suggest that when we finish, you give us all the.
I said, what do you see? Answer the
all.
question. That's what I asked. What do you see? Oh.
Please come again with your question.
I want to be sure the screen that you are seeing, that's why I want the confirmation.
For me, it's on and off. It's undulating. The network.
All right. Okay. Sorry. I've swapped what I was showing, but I want to make sure that what I'm trying to show now is the same thing that you are seeing.
So it's not quite stable. So.
Okay. Anyway, let me continue. It's okay. I assume that you say if you don't say you have the recording. Okay, so I made the point that the case of Hildebrand and Company Limited against Seller & Partners Limited is a leading authority for recognition of negligent misrepresentation. And just take note of the correction in the slide. The citation is not 1928, it's the 1964. Now, in that case, this is what happened, and I will just take aspects of the facts from the decision of Lord Reid. And this is, I'm just quoting a reading portion of the judgment, Lord Reid speaking on behalf of the House of Lords. This case, my lords, this case raises an important question. Whether in what circumstances a person can recover damages for loss suffered by reason of his having relied on an innocent but negligent misrepresentation. On having relied on innocent but negligent misrepresentation. Yeah, I'm teaching. Okay. Bye. I cannot do better than adopt the following statement of case from the judgment of McNair, quote, "This case raised certain interesting questions of law as to the liability of bankers, giving references as to the creditworthiness of their customers. The plaintiffs are a firm of advertising agents. The defendants are merchant bankers. In outline, the plaintiff's case against the defendant is that having placed on behalf of the client, AC Power Limited, on credit terms, substantial orders for advertising time on television programs and for advertising space in certain newspapers on terms under which they, the plaintiffs, became personally liable to the television and newspaper companies. They caused inquiries to be made through their own bank of the defendants as to the creditworthiness of AC Power Limited, who were customers of the defendants and were given by the defendants satisfactory references. These references turned out not to be justified, and the plaintiffs claimed that in reliance on the references, which they had no reason to question, they refrained from canceling the orders so as to relieve themselves of their current liabilities. The appellants, becoming doubtful about the financial position of AC Power Limited, got their bank to communicate with the respondents, who were AC Power's bankers. This was done by telephone, and the following is a contemporaneous note of the conversation which both parties agree is accurate. Quote. So this is a telephone conversation between the bankers of AC Power Limited and those who place the advertising. Quote. Helen Partners Limited, minute of telephone conversation, call from National Provincial Bank Limited. Person called L. Heller concerning AC Power Limited. They wanted to know in confidence and without responsibility on our part the respectability and standing of AC Power Limited and whether they will be good for an advertising contract for 8,000 to 9,000 pounds. I replied, the company recently opened an account with us, believed to be respectably constituted and considered good for its normal business engagement. The company is a subsidiary of Penna Industries Limited, which is in liquidation. We understand that the managing director, Mr. Williams, is endeavoring to buy the shares of AC Power Limited from the liquidator. We believe that the company will not undertake any commitments they are unable to fulfill. So this was a telephone conversation, right, between the advertising company and then the bankers of AC Power Limited, which was going to be giving advertising on credit basis. Now, some months later, the appellant sought a further reference, and on 7th November 1958, the City Office of the National Provincial Bank Limited wrote to the respondents in the following terms, quote, Dear sir, we shall be obliged by your opinion in confidence as to the respectability and standing of AC Power Limited, and by stating whether you consider them trustworthy in the way of business to the extent of £100,000 per annual advertising contract, yours faithfully. So simply put, they wanted to get a judgment, like financial opinion on credit worthiness of AC Power Limited, that if it was safe for AC Power Limited to be giving advertising on credit basis to the tune of, let's say, £100,000. So the advertising company decided to use their bankers to check on the financial standing of AC Power Limited. And this is the response that they got. On 11th November 1958, the respondent replied as follows, quote, for your private use and without responsibility on the part of this bank or its officials, dear sir, in reply to your inquiry letter of 7th instant, we beg to advise AC Power Limited, respectably considered company, considered good for its ordinary business engagement, Your figures are larger than we are accustomed to see. Yours faithfully. So this was the letter. Then to go on and on and on, and there was the subsequent exchanges. But in one of the communications, they will put in a statement that they do not accept liability, or what they call like a disclaimer, right? They put in what they call like a disclaimer, saying that despite all that we have said, we do not accept liability for any thing that you may suffer as a result of reliance on the statement that we have given. So eventually, they ran advertisement on credit for Isabel Limited, and Isabel Limited turned out not to be that good. So when it collapsed, the advertising company sought to sue the bank or the financial institution for giving opinion regarding creditworthiness of Isabel Limited before Isabel Limited was made to enjoy the advertising on credit. And the court said that if it had not been for the disclaimer, which the financial institution or the bankers had put in their statement regarding opinion on creditworthiness of Isabel Limited, the bankers or the financial institution will have been liable for negligent misrepresentation. But because of the disclaimer, the court said they were not liable. But I would like you to spend time. The judgment is very short. It's not a lengthy judgment. And the good thing about it is that if you read it, the court discusses all the cases which will be cited regarding fraudulent misrepresentation, dairy and pig. And you also come across the case of a Donogo and Stevenson later on when you are learning law of tort. You will come across that. So please make effort and read the case of Hedley-Brand against Heller and Partners. Let me show that slide again. Yeah, so we've also mentioned the case of SL Petroleum Limited against Marden. Another illustration of the principle in Hedley-Brand against Heller and Partners. Now, in the SL Petroleum Company against Marden, which we've talked about already, if you remember, when we are talking about whether a statement of opinion can actually give rise to misrepresentation. And you said that where the statement is made by an expert or someone professing to have certain expertise, then that could give rise to misrepresentation. And we cited SL Petroleum Company Limited against Marden as an exception to Bisset and Wilkinson. So just still relying on the same facts that we know, as far as SL Petroleum is concerned, the court made the point that when the SO Petroleum representatives forecast concerning the station's potential, in other words, how much money can be made, or the sales which can be made from that particular filling station, the court was of the view that the statement by the agent or the representative of the company regarding the sales potential of the station at the pre-contractual negotiation stage gave rise to a duty of care. That is to say that the maker of that statement had a duty of care, was an obligation to ensure reasonable care that the statement he was making will be accurate and it will not contain any error, as it were. And for that matter, the court held that ESO was in breach of the duty of care because of the error made by its representative regarding the sales potential of the station which was being sold. Consequently, ESO was liable in damages for negligent misrepresentation. Yeah, so that is illustration of the Hadley Brand against LM Partners principle, so to speak. We've also, of course, we talk about non-disclosure already, that you have no obligation to speak when you are making a contract with someone, but under certain situation, your silence can give rise to misrepresentation. You talk about Uberma contracts, that is contracts in which one party possesses full knowledge of all material facts and the other is not in a position to obtain the same information from any other source. So there is what they call information asymmetry. One party, by reason of its situation or circumstances, has more information which the other party can never have unless the one having it decide to share it. And that is why the law will say that in a situation like that, you are required to show good faith, be honest, and release the information accurately to the other party. And if you don't do that, then you could be liable for misrepresentation. So we mentioned like the insurance contracts and also contract to take shares from companies and family arrangements. In all this, we can see what they call fiduciary relationship, just as in the principal agent relations. When you discuss a purity of contract, you came across a principal and agent. Now between the principal and agent too, the agent has an obligation to disclose everything to the principal. So there are a number of instances where non-disclosure will give rise to misrepresentation. We just mentioned the cases and then you have to read them. So Lockyer and Wood Limited against the Western Australia Insurance Company is an illustration. And because you'll be learning the company's law, there's something of interest. If you look at the Companies Act of Ghana, I'm sorry, not Act 1992, Act 992. Just ignore the one, it's a mistake. If you look at the Companies Act 2019, Act 992, especially sections 3 and then 03 subsection 5, 313 and 314. They contain provisions on the obligation to ensure that information that you put in the prospectus of a company are true, and that if they contain untrue statement, then you incur civil and criminal consequences. For example, let's look at the Companies Act just in a minute, and then we'll come back. So if you look at the Companies Act 2019, Act 992, if you look at section 305, for example, headed the invitation to the public. So section 305, subsection 4, for example, that the prospectus shall not contain an untrue statement. And if the shares or debentures to which the prospectus relate are dealt in on a stock exchange, whether in the Republic or elsewhere, and then so it will go on and tell you that if it contains a false statement, then that is a serious wrong, which will attract severe sanctions. And if you look at section 313, for example, it said that civil remedy for misstatement or omission in prospectus. So misstatement or omission is the same as a misrepresentation in the prospectus. So 313 will tell us, quote, where a prospectus published in connection with the general or restricted invitation to the public in respect of shares or debentures of a public company contains an untrue statement, it is required to state or set a person specified is liable to pay compensation to the persons who require or dispose of the shares on the faith of the prospectus for the loss they may have sustained by reason of the untrue statement or omission, unquote. So if you look at section 313 of the Companies Act 2019, Act 992, we are being told that if, for example, a false information has been put in the prospectus, and on basis of that, someone has purchased a share or debenture and he or she has suffered loss, he or she is entitled to claim compensation for whatever losses he has suffered for the investment made by relying on such a false information. So let us keep that in mind. Of course, a family arrangement is also another type of case where you cannot remain silent and you must disclose information, otherwise that could give rise to misrepresentation. The well-known case of like the Goddard and Gordon, there was an arrangement between two brothers. The elder of him was believed to be illegitimate. For the illegitimate child means that was born outside the wedlock, for the division of the family estates. And it turned out that the younger brother, who had obtained an advantage because of his belief, had known all along that his brother was legitimate. And eventually, when the matter came to court, the court held that even after the lapse of 30 years, the agreement could be rescinded because the family arrangement of this sort was uberma fidei. It requires honesty and disclosure should have been made. Yeah, so what are the remedies for misrepresentation? Two main remedies, rescission and damages. We've talked about them variously as we come through the case. Rescission simply means that setting aside the contract. And this is available for all types of misrepresentation, be it innocent misrepresentation, fraudulent misrepresentation, negligent misrepresentation. So what is the effect of rescission? The effect of rescission is simply to wipe out the existence of the contract entirely and return the parties to the positions they were in before the contract was made. So like the status quo ante, the position that they were before the contract was made. And rescission has been developed in various decisions by the Court of Equity. And for that matter, all the principles which govern equitable doctrines or remedies, such as rectification, injunction, specific performance, are applicable to rescission. So all the equitable margins are applicable also to rescission. So let us keep that in mind. And knowing that rescission being an equitable remedy is really discretionary. And if you want the court of equity to exercise discretion in your favor, you must not be guilty of inequitable conduct such as dishonesty. In that regard, remedy of rescission will be lost. Remedy of rescission will be lost or will not be available to a party in certain circumstances where there has been lapse of time, meaning that we know that we say that delay defeats what? Equity. So where you become aware that you'll be victim of misrepresentation, but you don't timelessly take steps to set aside the contract, to rescind the contract, then after a reasonable delay, you will not be able to do that, as happened in the case of Leaf against International Galleries. So over there, you notice that the misrepresentation was discovered 5 years after the contract, and the victim did not act timelessly, and the court was of the view that because of the delay, rescission was not available. Another bar to availability of rescission for misrepresentation is affirmation. Affirmation will mean that where you are the representee or the innocent party, and you directly or indirectly, expressly or impliedly, affirm the contract with full knowledge of the true facts. In other words, having become aware that you are being a victim of misrepresentation, you continue to carry out your affairs, you continue to behave in relation to the contract as if you've not become aware of anything which entitles you to avoid the contract. You treat the contract as if it's in full force. Now, where that is the case, then you will not be able to rescind the contract because you have affirmed the contract. As lawyers will say, you cannot approbate and reprobate. You cannot eat your cake and have it. If you are aware of misrepresentation and you continue to behave under the contract as if nothing is wrong, then you cannot later on turn around and say they want to rescind the contract. And that is exactly what happened in the case of Long against Lloyd. The defendant advertised for sale a motor lorry, which had been described as being in exceptional condition, and told the plaintiff who purchased the car that it was capable of 40 miles per hour and did 11 miles to the gallon. 2 days later, certain defects appeared, and the plaintiff accepted the defendant's offer to pay half the cost of a reconditioned dynamo. On the following day, the plaintiff's brother set out to drive the lorry to Middlesbrough, but it broke down on the way, and the expert found that it was not in a roadworthy condition. The defendant's representation concerning the vehicle were untrue, although honestly made, and the plaintiff sought to rescind the contract on the ground of the defendant's innocent misrepresentation. And the court held that, one, that representation as to the condition of the lorry were innocent, and two, the journey to Rochester was not affirmation because the plaintiff had to have an opportunity to test the vehicle in a working capacity. And three, the acceptance of the offer to pay half the cost of the dynamo and subsequent journey to Middlesbrough did amount to affirmation, and therefore rescission could not be granted. So let us keep that in mind. Now, the third bar to the availability of rescission for misrepresentation is where restitutio in integrum is impossible. In other words, rescission is about restoring the parties to the position they were before the contract was made. If it is not possible to restore the parties to the pre-contract stage or pre-contract state of affairs, then rescission cannot be granted. And this may happen where, for example, the subject matter of the contract has ceased to exist or has radically changed its identity. In that case, rescission could not be granted. So we can look at the case of Vigas against Pike. And fourthly, rescission will also not be available where there has been intervention of third-party rights. You know, what equity seeks to do is to protect a person who has in good faith and for value acquired rights in property. And this is a very important equitable doctrine. The bona fide purchaser for value, you remember that? Good. So where a third party has acquired rights in a contract which was vitiated by misrepresentation, despite the fact that the misrepresentation can be made out, because of the intervention of third-party rights, a third party, a party who was not aware that the contract was vitiated and has gone ahead to give valuable consideration, acquire value under that contract, which is otherwise vitiated by misrepresentation, he is innocent, and equity will protect such a person. And for that matter, if the person affected by misrepresentation is seeking to have the contract set aside, the court will say no, rescission is not available because of the intervention of the third party rights. You can look at the case of Phillips and Bruce, Lewis and Ivy, which we met last week when Stanley discussed mistake with you. So let us keep these things in mind. Now, if you go to UK, there is legislation we call the Misrepresentation Act of 1967. Now, let me say that this legislation has no application whatsoever in Ghana. You're only citing it for comparative purpose, just to give you a sense of what pertains in UK, where we receive our common law and contract and everything from that. In 1967, they passed a legislation and sought to clarify certain aspects. So, for example, if you go to the Misrepresentation Act 1967 of UK, as I said, of UK, so don't apply it. Over there, for example, where the court declared that, yes, the contract which has been affected by misrepresentation is subsisting, the court could, for example, order that instead of setting the contract aside, instead of rescinding it, the contract should remain in force, and rather the affected party will be given damages. So that is, we have damages in lieu of what? Rescission. So instead of letting the automatic approach of equity that once rescission is made out, you can actually have the contract rescinded for good reason, where the court considers it equitable to do so, having regard to the nature of the misrepresentation and the loss that will be caused by it if the contract were upheld, as well as to the loss that rescission will cause to the other party. The court will weigh all this and say that, should we allow the contract to be set aside? If we are to allow the contract to be set aside, to be rescinded, what are some of the negative consequences? Now, the court will compare that with if the contract were to be upheld. Now, if the court is of the view that it will be more troubling having the contract rescinded because of misrepresentation, then the court will save the contract, let it remain in force, and rather award damages to the victim of the innocent or negligent misrepresentation. as the case may be. So that is, if you like, a bit of like a slight modification which have been made by English lawmakers to how the common law treat misrepresentation, as it were. Yeah, okay, so this will mark the end of discussion of misrepresentation, and then we will set up another class and we discuss for duress and undue influence. What I'm going to do is that I've done a lecture like this with the recording. So I will send you the slides and send you the recording, and it will be considered as written, so that when we meet in the course of this break, this long weekend again, we will move on with the discussion of illegality and public policy. And before we do that, if there are maybe any questions, we can take that. Good. So we will draw the curtain down here, unless there are maybe some questions that we will take. Otherwise, I have to go and meet your seniors in another class. Okay, not having seen any hand up, I'll draw the curtain down and have a very good day. We will set up another class.